Your Honors, we have this report. My name is Eric Mayer. I represent the appellant, Mr. Fernandez, who is in here today. Both issues on appeal begin at the same place. That's Florida statute 61.075, subsections 1 and 3, which provide that marital assets should be distributed equally unless the court determines that there's a justification for an unequal distribution of assets and makes specific findings and articulates the rationale supporting the unequal distribution based on various factors, including the 10 set forth in 61.075(1)(a) through I. The first issue is, frankly, concerns the most basic application of this. The trial court very clearly laid out what an equitable distribution of property would look like. It would involve the division of the net values of the 10 properties, which included the marital home and 9 properties held by the parties' LLC, J&D Financial Services, which itself was a marital asset. And then an equalizing payment to account for the difference in the net values of the properties that each party was distributed. Most likely through inadvertency, the trial court did something different though. Something different than what it recognized would be an equal division of property. It ordered the wife to cause J&D Financial Services to transfer 4 real properties to the husband, but it did not require the husband to refinance the property or assume the debt. This resulted in an unequal distribution of assets, which of course the trial court did not explain or support with factual findings because—
Well, as to the latter option, assume the debt, that's not something the court could have really ordered insofar as the lender doesn't have to accept a transfer of a debtor from one to the other. They're a third party. So really the only way to have effectuated what you're suggesting is how you ascribe the equity and the payoff, right?
Correct. And what is commonplace is requiring a party to refinance the property, to take the debt in his or her own name, and providing that in the event that party doesn't do so, then the property will be sold after however many days the court gives. But it didn't do that. I mean, that's what happens all the time in family law. And frankly, that is the alternative to saying, okay, sell and split, or So when I say assume, correct. We're not going to require somebody to accept payments from him, but there's a way to effectuate that, and if the court wasn't going to do that, then it should have distributed the assets differently so the parties would have an equal distribution of assets. And in fact, well, I don't think what the court did was sufficient with respect. This isn't part of the appeal, with how it ordered the husband to assume or to refinance the debt on the Las Brisas food truck. It at least went further with that than what it did with respect to these 10 properties. You see in paragraphs, in page 996 of the record, just the contrast between what the court did or said in paragraphs 3 versus paragraph 5, where when it came to the food truck, said husband shall assume sole liability and responsible for the debt which encumbers the food truck. Didn't even go that far with respect to these 10 properties. And as the case that we cited in our reply brief indicates, Karkoff versus Robalota, it would be error even if the court just simply said you have to refinance these properties. And if the court said that, but didn't provide any directive in the event that they were not refinanced. But here the court didn't even go that far. It didn't even order him to refinance the properties. And I think that the appellee's primary argument seems to be that, well, it was so clear what the trial judge meant to do or thought he was going to do, that we should just essentially pretend that he did it. But unfortunately, the obviousness of the error or the inadvertency of the error doesn't change the fact that my client owns an asset, the LLC, that is still responsible for debt. And it doesn't give her the ability to enforce any kind of directive to refinance the property because it simply isn't there. So basically, the court made.
I mean, I'm thinking aloud here, and I don't know if this was argued, but can you just maybe satisfy from my concern, or I would have with respect to that point? In theory, if the former husband did not pay upon perhaps suitable demand or whatever, the portion of the debt that the earlier part of the judgment said he was to bear, could there maybe be an enforcement and contempt proceeding as to that? Or I guess the concern would be, well, yeah, but look at how the ED schedule came out. He got what he had coming, she got what she had coming. We're done. Could it play out that way?
Well, I suppose this would be a closer case if the court had actually gone so far as to order the husband to refinance the property, but not provide an alternative.
You can't get contempt on equitable distribution anyway. So it would just strictly be an enforcement kind of issue.
Right, and what's to enforce? There's nothing in here to enforce is the problem. I mean, we would be somewhere else talking about this if there was something in there to enforce, but there's not, and that is exactly the problem. With respect to the second issue, I think it starts in the same place, 61.075 subsection 1 and 3, which provides that if the court does not divide the assets equally, then it must provide findings in the judgment. I explaining the reasons and identifying, among other things, any of the 10 statutory factors listed, 61.075 A through I, and let me interrupt myself to ask the court. I neglected to. May I reserve 5 minutes for?
You are right now at, I can read this 12 minutes, so you have 7 minutes before you hit the 5.
Thank you. Now there's an argument that, well, there's no transcript, so maybe the judge, we'll never know if the judge said something on the record, made a finding, but there's nothing in the statute that would suggest that where an unequal distribution of marital assets is based on any one of these 10 factors, including section 1I, intentional dissipation, then the court need not include those findings in the final judgment if the court says it orally in front of the court reporter. So there's certain things that the court is required to put in the final judgment, and here it did not make findings that would support that would necessarily support.
Well, but we don't know. And to that point, I mean, does the statute say that it has to be rendered within the judgment itself, or just that the court has to make the findings?
It says in the judgment that let me
Do a
I'm
little-
sure
do a
I'm
little
thinking, I don't want to
textualism here.
misstate it. I don't want to misstate it, but 61.075 subsection 3. In any contested dissolution action where a stipulation and agreement has not been entered into file, the distribution of marital assets shall be supported by factual findings in the judgment or order based on competent substantial evidence with reference to the factors enumerated in subsection 1. And those are the factors that we're talking about, the factors that would justify unequal distribution. So it does say in the judgment or order.
Your argument then is a matter of statutory prerogative. That's just something that's got to be, if you're going to distribute unequally, it has to be rendered in writing and in the judgment.
Correct.
Okay.
Correct. And I think what gets lost here also is the fact that the asset we're talking about is not a real property. It is an LLC, membership interest that is what the parties own. And the LLC itself held other assets, and the wife for 10, 15 years was managing a portfolio of real property assets for the LLC. And not every transaction is going to look, in hindsight, is going to look like that was a great idea. So what the trial court did here was isolated a handful of transactions and decided that this marital asset, which is the LLC, would be worth more if not for these 4 or 5 transactions. Now, had this been a portfolio of technology stocks, for example, we wouldn't give the marital asset the benefit of all what they call home runs, but charge the wife for the consequences of all of the transactions that don't look as good in hindsight. So it's not fair to basically micro examine this one asset and say these moves were no good. These moves don't look good, and they were too close to the date of separation, and we're going to say that you're responsible for them. And so there was no finding that the manner in which the wife managed the LLC at any time, including during the end of the marriage, was wasteful or constituted misconduct, or even rose to the level of squandering of marital assets. And even then, under Roth, that wouldn't be enough. So at a minimum, the wife is entitled to a clear finding and a clear explanation that she engaged in misconduct and that her misconduct damaged the marital asset. Without that, we simply have an unequal distribution without the findings that are required to be set forth under 61.075 subsection 1 and subsection 3. And I would just add that this misconduct for purpose of dissipation is supposed to be, it's an exception to the rule. So, I mean, the notion that you'd have to go back and start reviewing various transactions and second guessing them is exactly exactly what the rule does not say. It's that's simply second guessing the business judgment, even if somebody finds it to be terrible business judgment. I'm not saying it is. I'm not saying it is, but it's just not. It just doesn't rise. Nothing that the court put in the judgment rises to the level of the type of misconduct that the cases say would warrant charging her with the assets that or the proceeds that of either the transfer of the property. And the transfer of the property, by the way, included the debt. The other party who received the property also paid the debt, or the refinancing transactions. So I would ask your honors to reverse this to both issues 1 and 2.
Very good. Thank you very much. And you'll have 4 or 5 minutes for rebuttal.
May it please the court, my name is Mark Baseman. I'm here on behalf of Julio Mansa. I want to address one of the latter points that was made. First, I don't read the appellant's initial brief to be an argument about what factors the statute requires to be addressed in writing. That argument does not come through in the briefs to me. But even if it did, one of the factors that I recall is the court must make findings as to dissipation or waste. Well, the court did make that finding. The court did make the findings that would support waste or dissipation. The statute doesn't say the court must say the word misconduct or must say the word dissipation. The findings about the latter transfers do cover that. They do explain what the court was thinking. You know, it is not unclear to this court or to the parties why the trial court did what it did in this case. it doesn't hinder appellate review the way this is written. The lack of a transcript in this case, I maintain, is fatal to the dissipation issues. This court has no idea what facts were in front of the trial court, what other stipulations might have been in front of the trial court. And, as a total backstop, we have the Applegate case, Supreme Court case cited in all of these lack of transcript situations that not only says, it essentially stands for the fact that lack of transcript is fatal in these fact-based abuse of discretion situations, but it also adds that if any alternate theory could support what the trial court did, this court has to affirm. And that's why the lack of a transcript in this case is most problematic. Because even if this court doesn't believe that the facts as set forth in the final judgment rise to the level of misconduct or waste or dissipation that the case law talks about, this court doesn't know whether the facts would have supported reaching the exact same result under a different theory. And that's fatal. Now, I maintain that the court's findings are more than adequate to show the type of misconduct the case law talks about. And while misconduct is indeed an exception to the general rule, misconduct is not this high bar that the appellant is suggesting. And
Help me with this, Mr. Baseman. It just does seem like in reading the final judgment that I get what you're saying. If we were just looking at this in terms of the factual findings about what went on with the various transactions and the properties, we could reasonably infer that the court was making the sufficient findings that there was intentional dissipation, yada yada yada. Except when you read the distribution, it does seem like the court's assuming that it's doing a 50-50 equitable distribution. See what I'm saying? So that's what I'm struggling with is you're trying to ask us to infer something from some factual findings where it seems like when you get to the numbers, the judge seems to be proceeding under a different lens.
Well, I don't think I agree with that, because another way to look at it is that the court simply chose a date of valuation for J&D Financial that is not the date of trial. So the money that J&D Financial received as a result of, for example, refinancing transactions, that made it so J&D Financial had a lower valuation at the time of trial than it did on the date of the divorce. That's a valuation issue. That's abuse of discretion. Again, it wasn't really argued in the briefs, but that is well within a court's discretion. So what the court is essentially saying, the trial court, was, yes, the wife made these transactions which depleted the value of J&D Financial. So I'm going to ignore that. I'm going to use what the value would have been but for these transactions. I'm specifically talking about the refinancing transactions now, which is well within the court's discretion. So essentially, the court did an equal distribution of that asset as it existed back then. So it is consistent with what the court was trying to do.
I see what
The other point I would make is that it is not at all clear from the final judgment with respect to the refinancing funds that the court was convinced the funds were no longer in the wife's possession. What the court said is the wife has not provided a credible explanation for where the funds went. Those funds could be sitting in a bank account right now, and could have been in one that was addressed at trial. We don't know because we don't have transcripts. The court does not say the wife spent this money and I'm tagging her with it. The court says she hasn't explained where it went. And the court says J&D Financial didn't need cash and the wife didn't need personal cash. So to jump to the conclusion that these funds were dissipated is a step further than the final judgment in the record lets us go. Now, my position as a backstop is even if the court reads it to say there was dissipation, those findings are more than adequate. And again, we come back to this idea of misconduct, and I think it probably is a little bit of a shame that the courts chose the word misconduct. The Roth case, sort of the seminal case, at least in this district, and it does say misconduct, but then in the next paragraph it defines it. Misconduct is just one spouse while the marriage is breaking down, uses funds for their own benefit in a way that doesn't benefit the marriage, i.e. the other spouse. That's all misconduct is. These findings take the real property that the wife gave away. The court says she did it secretly. She gave it a property that I believe was stipulated to be worth $220,000. She gave it to a friend using a deed she made on her own, and it didn't benefit the husband in any way. That is misconduct under the Roth case. Now, the other case law creates an exception to the misconduct exception, which says once you find what constitutes misconduct, you can still avoid being tagged with that asset if you show that the funds were used for a legitimate purpose, meaning living expenses or attorney's fees. And in this case, the trial court made explicit findings that wife didn't have a need for any additional money, and that wife failed to provide any explanation for the use of the funds. This is more than enough under Roth and its progeny to constitute the kind of misconduct necessary to tag one spouse with an asset that no longer exists. And again, the final judgment is very clear. That property, I think it was 15th Street property, that's gone. The wife gave that away to a friend of hers for no consideration. No consideration. If we're going to call that something that's not even rising to the level of not squandering assets, then I don't know what could ever constitute misconduct in a divorce case. And again, if there was a transcript, if there was a factual dispute, there's an issue there. But when it comes to that property, I can't even believe we're arguing about that on appeal. She gave it away. She gave no explanation for it. She cost the marital estate $220,000. That is, I can't think of a better law school example of what would be misconduct in the divorce context. And I did want to address the first issue.
Yeah, please. I was just going to ask you if you could get to that, because I'm not quite sure I understand your argument. He got these properties, and he was supposed to get the debt on the properties he was awarded, but that hasn't happened. He didn't get that. There was no method that I could see in the final judgment to effectuate that. So, I mean, I read your argument, but I'm not sure it answered my concern about how is it that, you know, they're not correct.
I respectfully disagree. In my view, the final.
No, I know you do. Help me understand, because
I know.
I'm not.
I disagree. I wouldn't make it clear.
Yeah, no, I get it.
The final judgment says.
Disagree, but you're wrong.
I mean, maybe you want to do math, but it's like, you know, maybe you want to do the math, but the bigger picture is here, you're getting all these properties that have a certain value that value is reduced if you also owe the money on those properties. So he's getting the full value of the property. It's not reduced by the debt on the property.
But that's where I respectfully disagree.
Okay.
It is. The
So
court
explain it
says
to me.
you were being awarded, the husband, the properties and the debt. Now, maybe the word awarded isn't the best.
Yeah, but how is he liable on that debt?
If he doesn't pay the debt, they can come to court and seek enforcement. And the way to make
So
it.
your
But
position
they
is this can be enforced
Oh,
by
absolutely.
contempt?
Absolutely. And the statute requires only that the court designate who will be responsible for debts. It doesn't say they have to refinance, put the debt in their name, anything like that. And the way to
So
really
is the
highlight.
former wife supposed to just send him an invoice every month? Here's what you owe on these properties? Or excuse me, the corporation's supposed to send him an invoice monthly? How does this work in reality?
I think we have to be on the record to take
Okay,
guesses at
well,
that,
don't go
but
beyond the record.
I believe the husband, he worked for this company, he knows how to pay these debts directly. That's what I would say. And if he doesn't, he is the one responsible. And the way to
Well,
So
really
your
highlight.
position is that she could go into court and for an enforcement or contempt proceeding
Yes,
to compel him.
to compel him, and that in the enforcement proceeding, the court could clarify if it felt necessary. The court could even amend under the guise of clarification, as long as it doesn't change the rights that were assigned here. And the way to really understand it is, you can't imagine under this final judgment, let's say the husband doesn't pay the debts and the properties get foreclosed on. If he brought an enforcement action against her and said she was required to pay the debts, the trial court would look at this, even a successor judge would look at this and say, you were awarded the debts. it says the word awarded the debt. You're the one who has to pay. You can't enforce it against her or the company. And the same works in the other direction. It is very clear he is awarded it. The statute requires.
I think, I think our whole exchange here sort of highlights part of the problem that I think, I don't want to put words in their mouth, that they have with this judgment, is it says it awards, but we have to go outside the record to figure out how that actually happens.
But there's no requirement under the law for the trial court to say exactly how debts have to be paid. The trial court has to designate, and the word is designate under the statute, who is responsible. I think saying you were awarded debt designates that. Now, in a perfect world, does the trial court explain, you're gonna write a check on this date, you're gonna send this in? Maybe. We don't even know that was argued at trial. Certainly wasn't argued in the post-judgment motion for relief. We don't know that that was preserved. My point, my position is this is clear. I practice family law. We don't always see judgments that are clearer than this. To create a rule that says if you award a debt, here's 10 more things you have to say in a judgment. Certainly this court has the power to create that rule, but that's not in statute. There's been no case law provided by the other side saying when one party is made responsible for another party's debt, here's the checklist of things you have to say. So our position is merely that the trial court did what it had to do. Is it perfect? No, but neither are the solutions proposed by the other side. Assigning the wife the debt puts the husband in an incredibly precarious position and devalues the assets he was received. Because those assets, he can never be confident that they're going to be paid, that they won't be foreclosed on. That would result in a de facto unequal distribution. So again, our position is, this is not, it's not perfect. It's not perfectly written. It's not, we can't say.
It could have been done better, but it's not legally erroneous.
Exactly. Thank you.
Is that where you're going?
That is exactly our position, that it is not this court's job to sit over a trial judge's shoulders and say, here's how I would have written it. This is going to make life easier going forward. Courts have inherent enforcement jurisdiction because judgments are not always clear, because they sometimes need clarification, because parties don't always follow what they're clearly told to do. Our position is that's where this case goes next if it has to. It is not this court's job or prerogative to rewrite the final judgment in a way that just makes it more comfortable with what's going to happen going forward. And I'm happy to entertain any questions if there are more questions. Otherwise, that is my argument. Thank you.
So the statute that talks about assigning debts or saying who's responsible, that's not the statute we're talking about. We're talking about, or that's not the subsection we're talking about. We're talking about what the parties actually get. And the court ordered my client to cause the entity to deed 4 properties to the appellee. And the court did not order the appellee to do anything or to pay any debt. And the notion that
the point I was going to make earlier, isn't that implicit in the order? And the reason I say that is, if your client were to somehow be held liable for the debt, couldn't a successor judge, this judge retires, is gone, couldn't a successor judge look at this and say, and it may be more work for the successor judge, but couldn't that judge look through this and say, it is clear who was supposed to end up with which debts going with which properties? Your client ends up getting tagged because the institution has a promissory note, so they go after her. Wouldn't she have an enforcement mechanism and a successor judge can look at it and say, yeah, that's what was done here?
But I don't know how she would enforce it. I mean, it's not a credit card bill. This is now, if this gentleman does.
She is somehow held liable to a lender. Is it your position that she could not go into court and ask for relief, whether it's a contempt or other enforcement mechanism? I mean, you've been
I
doing
don't
this
know
for a
the
long
answer. I mean, I
You've been
wouldn't.
doing this for a long time.
No, I mean, look, the answer to the question is that if we were in that position, then I wouldn't tell her that it would be frivolous to go and seek to enforce it, but why should we be put into that position when the fourth,
Counsel, I'll answer
Go
that.
ahead.
When I was a family law judge, I had a couple of cases where for whatever reason, the parties that were 50-50 owners of LLCs or corporations, they divorced, but they wanted to keep doing the business together. It didn't make sense to me, but that was kind of the deal they struck. And if he's still got involvement with this LLC, we don't know, we don't have a transcript, but I mean,
we
for
have,
all we know, that could be the
well,
situation.
what we have is final judgment that says the LLC is completely my client's. She owns it. She owns everything in it except for the 4 properties that were deeded to him. So this is not one of those situations. And in fact, in the Kharkov case, it wasn't.
But it's not, but like you pointed out, though, it's not a situation where it was a total and complete separation insofar as it does seem like in the judgment that there's an award of debt.
I think it's very clear that the court, and if you read, like this.
Which is what the statute requires, right? I mean, that's, the judgment did what the statute requires. It listed the assets, it put in the factual considerations. It ascribed the numbers and the valuations to them. It said who gets what, it says who gets debts, who gets equity.
And the judgment ordered my client to do something. So my client's required to do something, but we'll just figure out what it is that the other side is going to do. And again, the Kharkov case specifically says and this is talking about a home, but when the court does, you know, it's not about telling somebody, oh, yes, write this check on this date, but it happens every day. And the Kharkov case said it would be error to not do it this way. When you give somebody an asset that has debt with it, and you've required them to refinance it, you have to provide some means to enforce that other than saying, okay, my client will just not pay it. And you know, the credit of the entity will be ruined, but this guy's gonna eventually come back and say, hey, why aren't you paying the
But
debt?
that's not a statutory requirement.
Well,
And maybe it should
the
be.
statutory requirement is to divide the assets equally or explain why it didn't. And it's very clear that if you look at in the record at the final judgment at page 995, where it's talking about the difference in the language in paragraph 3 on 995, which deals with these properties we're talking about, and the language on paragraph 5 on 996 makes it very clear. The judge just forgot to do it, and we wouldn't be standing here. And I'm not going to go outside the record if this wasn't a problem. We're not here to look for problems. But you know, there was clearly. We certainly shouldn't be encouraging trial judges to say, hey, here's your equitable distribution chart. You guys figure out how to get assets from one person to the other. That's just not how it works. And at least in the Kharkov case, suggests it's error to do it that way.
And Mr. Mayor, you've gone a little bit over your time, so just take a few seconds to conclude.
Thank you. I just want to, on the other point, I just wanted to say one thing is you know, the notion that we have to sit and guess whether, oh, maybe the trial judge really meant that my client still has the funds because maybe she didn't, maybe it wasn't misconduct, but maybe he thinks she still has them, is the very problem that we have to guess at what is the basis for an unequal distribution of assets. Thank you, Aaron.
Very good. Thank you both very much. That concludes the oral arguments for today. We are adjourned. All rise.